Good morning and welcome to the Public Service Commission of South Carolina. We are in the continuation of the hearing in docket 2022-89-G. This is the application of Piedmont Natural Gas Company Incorporated for adjustment in rates and charges. We have changed our format a little bit this morning with the parties being virtual. But before we begin, let's take a roll call of commissioners, then we'll get to a roll call of the parties. Present in the hearing room, we have Commissioner Justin Williams, Vice Chairman Powers, Commissioner Thomas, Commissioner Caston, and Chair Belser. Appearing virtually, and we have Commissioner Irvin and Commissioner Carolee Williams. Now, we have the parties appearing virtually today, and let's do a roll call of the parties. Make sure we've got everybody. For Piedmont, I see Mr. Jeffries, Mr. Hessling, and Mr. Richardson. Can everybody hear us?
Yes, ma'am.
Department of Consumer Affairs, I see Mr. Hall. Anyone else, Mr. Hall?
Connor Parker is with us as well.
Okay. Is he in the room with you, or has he got a separate connection?
He has a separate
Oh, there he
connection.
is. Thank you. I'm not very good at looking at the Hollywood Squares boxes here. South Carolina Energy Users, I see Mr. Elliott. And Office of Regulatory Staff, I see Ms. Gibbon. And I see Mr. Huber's name. Is he on?
Madam Chair, yes. Mr. Huber is on. He's getting connected.
Okay, that's fine. Thank you. We will revert to some prior practices here. If people have issues with their connection, somebody needs to email or notify us as soon as possible. So, let's see. Commissioner Williams, you had a request for one of the stipulated or ORS witness. Would you alert ORS as to what you're looking for, please?
Yes, ma'am. Thank you, Madam Chair. I would like to hear from whoever the Office of Regulatory Staff believes is in the best position to explain to the Commission why the stipulation is just, fair, and reasonable and in the public interest, especially considering all the testimony that we heard, the live testimony that we heard during the course of this proceeding. Obviously, if any other party who has stipulated their testimony, stipulated a witness's testimony wants to address that, you are welcome to that opportunity, but specifically, I just wanted to hear from the Office of Regulatory Staff on that issue. Thank you, Madam Chair.
Thank you, Commissioner. Ms. Gibbon, can you arrange to have a witness available this morning?
Madam Chair, can we get back with you as far as the witness for that particular topic?
Thank you, Mr. Huber. Yes, I understand it may take you a few minutes to get the witness and or to notify us as to who it will be. So if you could just have that, I think Piedmont has one witness to present. As long as we know by the end of that time, we'll be fine.
Thank you, Madam Chair. And am I correct that as far as the other ORS witnesses, there are no questions for them? Two of the witnesses are experts, which if there's no questions for them, we would like to excuse them.
I have not heard of any other requests, Mr. Huber.
Thank you, Madam Chair.
With that, Mr. Jeffries, is Piedmont ready to proceed?
Yes, Piedmont's ready to proceed. Also, Madam Chair, just one request. Ms. Cousins is unavailable to testify this morning, so we would ask the Commission's permission to have Ms. Powers testify on behalf of Ms. Cousins. Ms. Powers is Ms. Cousins' direct supervisor and is more than suitable to testify on her behalf.
Okay, let me just clarify one thing. Was it going to be Ms. Cousins or Ms. Powers that Mr. Hall wanted to cross-examine?
It was Ms. Powers.
Okay.
I just wanted to bring this up first as an initial preliminary matter.
I have not had any commissioner tell me that they needed to hear live testimony from one of the settlement witnesses. So if we don't hear anything by the end of, if I don't hear anything about commissioner wanting to question one of the settlement witnesses. I think y'all offered to stipulate that testimony in yesterday, did you not?
Yes, ma'am.
So we may be doing that. If we do need to hear from Ms. Cousins, Ms. Powers can adopt that testimony.
Thank you.
Thank you.
Madam Chair, I wanted to alert you that Ms. Powers texted me a minute ago and said she was having to re-log on to the conference because she lost her connection, and I'm not sure if she's back on yet.
I am told from the TV booth in the back that that she is on.
Oh, excellent. Okay. Then I will let Mr. Richardson proceed.
Let's make sure.
That case,
Okay.
oh, sorry.
Mr. Richardson, go ahead.
Madam Chairwoman,
Commissioner Williams?
thank you. As someone who's participating virtually, I just wanted to alert our technicians that those of us, at least in my case, can only see the Hollywood Square. So when it's time for someone who's in the room to be testifying or talking, I know we have the ability to shift and see that view as well.
It takes a little bit of maneuvering, so just be patient with us, please, because it's not instantaneous. It takes a little bit of time, and it may go back and forth from the attorney asking the question to the witness, but they will work it in when they can.
Madam Chair,
Vice Chair Powers.
I think Commissioner Williams, there's a setting on these screens up in the corner that she can change it. What's being seen is big, and that the Hollywood squares are little. She could do that herself, and that's what I've always done when we have hearings.
Just a moment. We're just a moment from our. We need to stand at ease. We've got a technical issue here in the hearing room. Can y'all just stand at ease with us for a couple of minutes? Thank you. Thank you. Appreciate everyone's indulgence as we had a little technical issue here in the hearing room that we needed to get worked out. We do need to take roll again just to make sure we've got especially commissioners, on the record here. So let's take a roll call of commissioners. Present in the hearing room, we have Commissioner Justin Williams, Vice Chair Powers, Commissioner Thomas, Commissioner Caston, and Chair Belser. And appearing virtually, we have Commissioner Irvin and Commissioner Carol Lee Williams. I think we've got all the parties, and Mr. Richardson, I believe you were up.
Yes, ma'am. Thank you. Madam Chair, Piedmont Natural Gas Company calls PK Powers to stand to be sworn in as a panel witness.
As a panel?
I'm sorry, as a witness. Sorry.
Okay. Thank you.
Sorry.
Ms. Powers, the court reporter will swear you in. You're on.
Oh, thank you. Ms. Powers, okay, thank you. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you.
Ms. Powers, can you please state your name and business address for the record?
My name is Pia Powers. My business address is 4720 Piedmont Row Drive, Charlotte, North Carolina, 28210.
By whom are you employed and in what capacity?
I'm employed by Piedmont Natural Gas Company, Incorporated, as the Managing Director of Gas Rates and Regulatory.
Did you prepare or cause to be prepared on your direction 10 pages of direct testimony that was pre-filed with the Commission on April 1, 2022?
Yes, I did.
Do you have any changes or additions to your direct testimony?
I do not.
Ms. Powers, if I asked you all the questions contained in your pre-filed direct testimony here today, would your answers still be the same?
Yes, they would.
Madam Chair, at this time, I move that the pre-filed direct testimony of Ms. Powers be entered into the record as if given orally from the stand.
Ms. Powers' pre-filed direct testimony will be entered into the record as if given orally from the stand.
Ms. Powers, did your pre-filed direct testimony also include 3 exhibits labeled PKP1, PKP2, and PKP3?
Yes, it did.
Do you have any corrections to those exhibits at this time?
I do not.
Madam Chair, at this time, I move that the exhibits labeled PKP1, PKP2, and PKP3 as attached to Ms. Powers' pre-filed direct testimony be entered in as the next composite hearing exhibit.
Ms. Powers' pre-filed exhibits PKP1 through PKP3 will be a composite hearing exhibit marked for identification as hearing exhibit 12 and entered into the record of this case.
Ms. Powers, have you prepared a summary of your pre-filed direct testimony in these proceedings?
I have.
Can you please present your summary to the Commission?
Yes. My name is Pia Powers. As a background, my tenure at Piedmont began in 2003 after working as an economist with the Energy Information Administration. Initially at Piedmont, my responsibilities pertained to Piedmont's prudent upstream pipeline storage and capacity planning and related activities at the Federal Energy Regulatory Commission, all of which was in support of Piedmont's continuous provision of safe, adequate, and reliable natural gas service to its customers. Since 2006, I have devoted to several roles of increasing responsibility and oversight of Piedmont's rates and regulatory affairs. My responsibilities during this now 16-year period have included all Piedmont rate proceedings before this commission. On April 1st, 2022, I pre-filed direct testimony and exhibits in this docket. My direct testimony and exhibits explain and support 4 matters. First, they explain Piedmont's revenue request. Second, the impact of the revenue request on our customers. Thirdly, the proposed changes to certain provisions of Piedmont's tariff. And lastly, Piedmont's election to resume operation under the terms of the Rate Stabilization Act, RSA for short, upon conclusion of this general rate proceeding. This concludes my summary of my pre-filed direct testimony, but I desire to also remark that I will gladly address any question that the Commission or parties, if that's appropriate in this proceeding at this point. Any questions that they have pertaining to Piedmont's historical and prospective operation under the RSA. And of course, I offer to address any other questions pertaining to Piedmont's rates that may please the commission at this time.
Thank you, Ms. Powers. Madam Chair, Ms. Powers is available for questioning from the parties and from the commission.
Thank you, Mr. Richardson. Let me find the list. Mr. Elliott? I think that's no questions, but Mr. Elliott?
No questions, Madam Chair.
Thank you. Mr. Hall?
Yes, Madam Chair, thank you. Ms. Powers, good morning. Can you hear me okay?
I can, yes.
Thank you for being with us. Hopefully this won't take too long, but I did want to ask you a few things about your testimony. In that you state, and you covered it a little bit in your summary, that on page 1 of your direct, you state, I am responsible for a variety of regulatory matters, including leading the development and execution of all rate requests. Is that right?
Yes, it is.
And in your role, are you aware of the reasons the company may seek a rate case?
Yes, I am.
Could you tell me a few of those reasons?
Ultimately, it's a calculation where we determine if we have an insufficient overall rate of return.
Just a moment, Ms. Powers. Can you get closer to the microphone? Our folks are working to boost your volume, but I think we need you to get a little closer. We can barely hear you.
Okay.
And if you wouldn't mind starting that answer again, please.
Will do. Actually, would you rephrase or restate the question, Mr. Hall? I think that would get me back into the mode here.
No problem. And in your role, are you aware of the reasons you're aware of the reasons the company may seek a rate case? And I was just wondering if you could tell me a few of the reasons the company might file a rate case.
Sure. I think the most overarching reason that would Piedmont, or frankly any large any natural gas distribution utility would seek a general rate case is to modify its rates in order to, and the rates allow the company recovery of its cost of service, and that's including a return on its rate base.
And I know you all typically have filed, under the RSA process, but another reason might be, operating expenses increase. Could that be another reason?
Operating expenses, which there are a variety of components of that, but that is something that it's a component of our cost of service. So yes.
And as would capital projects and capital spending would be a component of that as well.
Capital spending, once an asset is in service, the company records depreciation expense, and that's a component of operating expense that you just spoke to. So yes, the two go hand in hand.
Thank you. Well, I'm going to try to share my screen, and hopefully just let me know if you can't see it, and just make sure I get the right one here. Can you see this?
Yes, I can.
And does it look like it's the revenue requirements formula?
It's a characterization of it.
Mm-hmm. Madam Chair, can you all see this okay in the hearing room?
Yes, we can, but Ms. Powers, we do need for you to talk louder, please. I know,
yes.
I know it's difficult,
Thank
but
you for the reminder.
thank you.
I appreciate
it. Thank you. So I just wanted to put this up to kind of put a little perspective on some of the things we've talked about the past few days. Like you said, this is one sort of demonstration of it. I'll say when I first started the department, another outside attorney that does utility work gave this to me, and I find it helpful as a reminder. But looking at this, we can see that the rate base, I think this is that would be all the things the company has built, right?
That's a simplification, but yes, I agree with that.
And you mentioned depreciation, which is how that gets accounted for, sort of, break down over the life of it. That's a separate little D right there under expenses, right?
Yes. On our financial statements, it's a it's a component of operating expenses, but I agree and I follow your slide here.
And the little r right there, you can see next to rate base, that is the rate of return we've been talking about a lot the past few days, right?
Yes, it is.
And I believe in Mr. Coyne's testimony, he mentioned that the company has $4 billion in projects planned for the upcoming years. Does that sound about right?
Subject to check, yes.
And as discussed with Mr. Bauer yesterday, since 2018, Piedmont has received capital contributions from Duke totaling $775 million. Does that sound about right?
Subject to check, yes.
And that is money that will fund those projects, correct?
Yes.
And does Piedmont already have that money?
I am not in the financial department to speak to cash flows, so it is on our company's books, yes, that capital contribution, and as comfortable as I am.
I appreciate it. And looking at this formula here with the rate base and the little d, again, this is how the spending for those projects again would be accounted for in this formula.
It's the revenue requirement computation, yes.
In the little r we're talking about, that doesn't impact that spending, does it? I mean, as far as the revenue requirement formula is concerned, that money is accounted for under the rate base and depreciation.
Mr. Hall, I apologize. I'm not following the terminology you're using because I hear you mixing a revenue requirement computation, which is a rate making formula for the purposes of rate proceedings, with cash flows and cash management, which of course, Mr. Bauer yesterday, that is his area of expertise.
I understand. I'll try to maybe make it a little bit more precise. The rate of return is a separate component of this formula than expenses and taxes and depreciation. Would you agree to that?
Yes.
And essentially this little r represents the return to the shareholders. Once you multiply the little r times the rate base, that is, as it says here, the return dollars on rate base, and essentially the rate of return on investment to maybe not shareholders, but to Piedmont.
Mm-hmm. You've represented it as the weighted average cost of capital on your slide. And so the weighted average cost of capital is a blend of equity and debt.
That's right. That's right. As we talked about, you multiply the return on equity times the equity component, and you multiply the cost of debt times the debt ratio. And that's how you add those two up and you get the little r here. That's right.
Yes. So it's a blend of both equity and debt for that return that you've got with the little r.
Thank you. I'll stop sharing that now. I just wanted to kind of put it in perspective because it helps me understand when we're talking about these different things where it fits in that formula, and I thought it might help the commission as well.
I need to ask both witnesses, and I'm guilty of this too, but please don't trail off at the end of your statement or question. It's something we all do, but I need for you to still talk loud through whatever you're saying. Thank you.
Thank you for the reminder, Madam Chair.
Yes, thank you, Madam Chair. And just to repeat that, I just saying it's something that helps me put things in perspective when we're talking about these different numbers, and hoped it would for the commission too. But I'll move on from the formula itself. Do you recall that Mr. Rothschild testified that his ROE and cap structure would produce around $35 million as the rate of return portion of the revenue?
Not specifically, no.
Subject to check, would you concede that roughly 35 million?
Subject to check.
And do you recall, and he also testified that the original application would produce for that rate of return portion, again, that return dollars on rate base that we just showed, that would be under the application about $47 million?
Subject to check.
Okay. And subject to check, would you concede that the settlement with a 9.49 ROE and 53.5% equity would reduce this number to approximately $44 million.
Subject to check again.
And I'll tell you that number comes from, if you look at attachment A to the settlement agreement, sort of very last page, very last number, it shows it about $35 million, but that is not counting taxes. So as Mr. Rothschild discussed, that number is trued up to account for the taxes the company pays on that. That's how I got that number.
I see it now. Settlement attachment A, that is the net operating income for return for the company. 34.9 million, yes.
And would you agree that number does not include taxes? That is, taxes have already been subtracted to get to that number.
Yes, that is correct.
Thank you. And so even assuming the commission adopted all of Mr. Rothschild's recommendations, we're talking about a $9.5 million difference in shareholder returns. Does that sound about right? He said originally 35 million under his calculations originally. That was on being applied to a higher rate base. He had about $35 million for returns to the shareholders, and we just established that it's maybe approximately $44 million under the settlement.
Mr. Hall, I think what you're saying or asking is the difference between the net operating income for return under Mr. Rothschild's recommendations versus the settlement. Is that another way to think about your question?
Yes, it is. Thank you.
So subject to check, I will agree with that.
Thank you. And the company's rate base with the settlement would be about $501.5 million. Is that right?
The company's rate base under the settlement is $501 million. That's a per book number. Yes.
And the operating expenses under that agreement are around $160 million per year. Does that sound right?
Yes, it does.
Okay. So, and again, regardless of what the commission decides about ROE and cap structure, the company is going to recover those rate base and operating expenses we just discussed, right?
No, its rates are designed to recover that, but whether the company does or not is a matter of speculation. That will be determined over the first year that the rates are in effect.
Fair enough, but rephrase it, not necessarily recover, but those numbers, the $501.5 million in rate base and $160 million in operating expenses will be reflected in that revenue requirement regardless of what the commission decides on ROE and cap structure.
Yes.
Thank you. So we talked about yesterday how under the settlement, this is approximately a $10 per year increase for customers, if I recall. Does that sound right to you?
Yes, for residential customers.
And Commissioner Irvin commented that that is a pretty small number compared to other recent filings from other utilities. And I believe he specifically mentioned the annual gas adjustments. Do you recall that?
I do.
And Piedmont also has several other types of cases it can file that may increase customer rates too, right?
One other case under the gas cost recovery mechanism in rules in South Carolina. That is the nature of the other proceeding under which the company adjusts rates in South Carolina.
And if fuel costs go up or go down, that'll be passed through in those annual cases to customers.
Yes.
Are you aware of any other filings Piedmont may make in the next year or so that would increase customer rates?
No.
Piedmont will have an annual gas case. Do you know whether they expect the rates to go up based on those gas adjustments?
No, we evaluate that monthly. And so I do not have anything to share on that at this point in time.
Fair enough. Thank you. So move on. I understand you're not an ROE witness, but in your testimony, you do discuss an important point related to the ROE and the RSA. that I want to ask you about. And
Yes,
your
let me flip
direct,
to my testimony, if you give me a moment.
yeah, and I'm specifically looking at page 5 of your direct, lines 5 to 13.
Page 5, which lines, please?
5 to 13.
Yes.
And basically here you say that the revenue, the general rate case revenue requested here is significantly smaller than the request would have otherwise been, would have been filed under the RSA. This reason is because such a revenue request by the company under the RSA would have been required to be made at a much higher return on equity, namely the return on equity authorized for Piedmont in its last general rate case, which was in 2002. Is that correct?
Yes, that statement is correct.
And the company's last authorized ROE was 12.6%, correct?
The last authorized ROE from a general rate case. Yes, that's correct.
And due to yearly settlements with the ORS that were adopted by the commission, it is currently 9.8, right?
Correct.
And are you aware that every Piedmont RSA case for the last 12 years has resulted in a settlement?
That's correct.
And so the only reason Piedmont has filed this rate case is because of a settlement, I believe it was in the 2019 RSA case, correct? Where you agreed with ORS that you would file for a general rate case?
Yes, that was the driver for Piedmont filing this general rate case.
And then the ROE, likewise, the ROE authorized here will be used in every RSA rate case going forward unless Piedmont settles for a different one or files for another rate case.
Correct.
Under the RSA, we've talked about this a little bit in the past few days too, but the RSA allows for a revenue true up regardless of the reason Piedmont's revenues aren't within that 0.5 range. Is that right?
I don't characterize it as a true up, but for purposes herein, yes, I agree.
Thank you for simplifying that. I understand. So again, those reasons could be you lose customers, your cost increase, or maybe the company performs poorly. It doesn't matter, right? You will get that, we'll call it a true up. You'll get that true up.
It goes through a proceeding. The ORS audits it for the prudency of the company's investments and costs for rate making purposes. According to that, the results of that audit drive the exact nature of the cost that the company is recovering. And I will share that in many RSAs, say the majority of the ones that I've been involved with, the main driver for the company's reduction in its rate of return, and hence the increases that have resulted from the RSA proceedings, has been largely driven by the increase in depreciation expense. And that is because the company has been making prudent investments in the state of South Carolina over these years in order to provide continuous, safe, and reliable natural gas service to its customers.
And I didn't mean to imply that the company is performing poorly or not making prudent investments, but as far as you know, the RSA doesn't speak to that issue. It simply speaks to, again, truing up the revenue around the ROE.
It's in each of the RSA proceedings, and Mr. Hall, forgive me, I want to be very clear and accurate here. In each RSA proceeding, Piedmont's base rates have been updated in order to reflect its cost of service based on its rate base and costs for the test year in each RSA. Say true up, we have had in each of our in many of our RSA proceedings, literally not each one, in many of our RSA proceedings, and we have had a rate increase result, a revenue requirement adjustment that resulted in a rate increase. Okay. Our returns have been, and that is because our return, as shown in the ORS's audit report and the company's filing as well was insufficient. The rates then get updated. The company is never made whole for any insufficient return it incurred in the test year in the RSA. All that occurred under each of these RSA proceedings was an update to base rates in order to give the company an opportunity to earn that return in the following year. And so that's what the differentiation of true up. I think true up can mean different things to different people. So I wanted to be very clear here.
Appreciate the clarification. Thank you. You heard Mr. Coyne's testimony over the couple of days ago. Is that right?
Yes.
Okay. And would you agree that his recommendations are based, at least in part, on projected inflation and interest rate increases?
I've heard him speak to that. I think he did an analysis both under current and projected rates.
That's right. And I know you don't have it in front of you, but in his direct on page 41, he reflects that. He says, well, I would typically rely on the results of analyses using projected interest rates, especially given the current market environment and the prospect for inflationary pressure in the near future. I considered the range using both current and projected interest rates. So that sounds about what you were saying. Is that correct?
Yes.
And again, subject to check, his ROE results, again, maybe not his recommendations, but his results range from maybe 9 to 11%. Does that sound about right?
It does.
Okay. And so if he's right about these prospective inflationary pressures and interest rate increases, then Piedmont's requested ROE arguably may be appropriate. Would you agree?
Yes.
Okay. But what if he's wrong and the interest rates don't come out to be what he forecasted? In that case, if the commission granted rates based on his models, they would be using based on forecasts that didn't come true. Isn't that right? So if he's right, interest rates go up. He's recommended a 9.9. He's right.
I don't know what that would entail. That would require his reanalysis based on that. So I'm uncomfortable to speak to what recommendation on ROE he or any other witness would proffer in this proceeding. You know, if they kind of ex ante were able to look at the actual interest changes as opposed to the projected. So,
well, I'll ask it a little bit different way. Mr. Coyne uses some projections in his analysis, right?
yes,
And so his results are at least partially influenced by these projections, right?
yes,
And so if the PSC grants an ROE based on his recommendations, it would be doing so at least in part based on projections, right?
at least in part, yes. I think he spoke to many components driving his recommendation.
So if given that, if the commission did grant an ROE lower in the lower ranges of these experts, and then it turns out the projections are right, and it looks like maybe Piedmont should have had a higher ROE because these forecasts came true. In that case, Piedmont could come back in for another rate case, right?
If Piedmont has the opportunity to come in for another rate case, I don't think anything in its election of the Rate Stabilization Act, its election to operate under the RSA, precludes Piedmont from seeking a general rate case. And on the flip side, it does not preclude, to my knowledge, any party from seeking the commission under the appropriate procedures and laws of this state to file that Piedmont is over earning. So that the RSA, as I understand it, and you know, my background is I'm not an attorney, but as I understand it, it doesn't diminish the rights already afforded. It doesn't diminish any other rights of parties.
And I'll admit, I'm not aware, I don't disagree that that's a possibility that a party could ask the commission to have Piedmont come in for a rate case because they're over-earning. Are you familiar with the time where that's happened, where a party has requested a utility to, request the commission require a company to come in for a rate case because they're over-earning?
I can only speak to Piedmont, and that has not occurred in my tenure here at Piedmont for Piedmont.
Now, I will admit, under the settlement agreement, the parties to the settlement agreement can require Piedmont to come back in, I believe, maybe in 5 years. Does that sound right?
Yes.
Okay. That's all the questions I have. Again, I appreciate your time. I realize you're not an RE witness, but obviously your job does touch on some of these issues. So I appreciate your time. Thank you.
Thank you, Mr. Hall. ORS?
No questions from ORS. Thank you.
Thank you, Mr. Huber. Commissioners, any questions for Ms. Powers? Commissioner Thomas?
Thank you. Good morning, Ms. Powers.
Good morning, Commissioner Thomas.
It's been good seeing you and others here in person this week. And sorry when you're up for your part of the show that you're not here in person. But I hope you're feeling well today.
I am, and likewise.
Thank you. I just have one question, and it relates to rate design at a high level. So are you the appropriate person to talk with?
Yes.
Okay. So one of the interveners was particularly focused on rate design and presented a witness, Mr. O'Donnell, I believe, and he was talking about problems with the rate design that went back a long time, maybe 20 years plus or minus to the last rate case. And the rate design, as I understand it, is covered in the stipulated agreement. It looks to me like it's probably part of item number 8. And my question for you is just in terms of the overall fairness for all the customers in South Carolina and the appropriateness of the rate design. Does it address the fairness issues for all customer classes?
Yes, it does.
Thank you. That's all I had. Hope you have a nice day.
You too. Thank you.
Commissioners, any other questions for Ms. Powers? Commissioner Caston?
Good morning, Ms. Powers.
Good morning, Commissioner Caston.
The beautiful forest behind you, is that virtual or is that real?
It must have been a default fake background on this WebEx. I didn't choose it, to my knowledge.
Well, I'm sorry it's not real because that's really lovely. I guess sort of in lines with a question that Commissioner Thomas asked, and as I look at your direct testimony, page 2 of 10, where it talks about the purpose of your testimony in the proceeding. And one of the items, item number 2, specifically your testimony, you say addresses item 2, the impact of the revenue request on the customers, which is really I wanted to ask you a couple things about, if you don't mind.
Yes, please do.
Do the rates in your testimony include the gas cost recovery mechanism, which I think was 155, that was made in June?
At the time the company filed this general rate case, I think the prior GCRM version was in effect on April 1st. And so, as you know, the cost of gas has 2 components, commodity and demand. And in each RSA proceeding, and in this rate case, we have proposed a modification for the cost of gas demand component. The commodity component, which the rates that are reflected in the stipulation are no different than the prior version of the GCRM. So the stipulation seeks to modify two of the three components of our rates. The margin component, which is the non-gas cost component, and the cost of gas demand. If the commission were to approve the rates that are shown in the stipulation, the current GCRM would remain in effect. It doesn't override it. And of course, the company has an opportunity with 2 weeks notice to file to modify the GCRM rates. And so company will do its normal frequent monthly, if not more frequent than monthly evaluation. And if another change was warranted to the GCRM for commodity, would make such change. So in summary, what you see in the stipulation reflects the cost of gas commodity rates components that were in effect as of April. It's a long answer, but I wanted to make sure I was accurate in providing you that response.
Well, let me ask this to make sure I understood it, because I really tried to track it all. But
Okay.
So will the customer bills
Yes.
actually be at the rate including the June GCRM update plus the amount of revenue increase from this rate case?
You got it. That is how it would work.
But that's not reflected in the testimony yet, correct?
Yeah, the stipulation did not account for the change that took effect in June for the GCRM.
So nothing in the record at this point reflects that.
Correct.
So, okay. So do you know what an average residential bill would look like, considering the actual rates?
Yeah. Because the GCRM that took effect in June was an increase to the benchmark cost of gas, essentially it increased the denominator. So the percentage change resulting from this proceeding would be slightly smaller than as indicated in the stipulation exhibits. For a residential customer, we've indicated, I'm looking at my notes, give me a moment to put this together.
Well, while you do that, and I want to make sure you're responding or I asked the question correctly. If I understood you correctly, there's nothing in the record of the stipulation that would reflect the June GCRM. So if there's nothing in the record that reflects that, I guess what I'm asking, then there's nothing in the record that will reflect what that would look like to the customer. Is that correct or not correct?
That is correct.
Okay. Then that's really the only questions I have. I mean, unless you want to provide some other information.
I think the increase to the customer as a result of the stipulation, regardless of the commodity rate, the cost of gas commodity rate, is roughly $10 a year, an 82-cent increase. Folding in the current GCRM rates, the ones that took effect in June, doesn't impact that dollar quantification. It would impact the percentage change, but not the quantification that the settlement rates increase an annual bill for a residential customer by approximately $10, approximately 82 cents per month as levelized. Nothing about the June benchmark cost of gas change under the GCRM affects that computation.
Understand, and it's a pass-through, so the pass-through is just a pass-through anyway, but the customer still pays that pass-through.
Absolutely, I agree with that.
Understand, and I do hope you feel better. Thank you, ma'am.
Thank you.
Commissioners, any questions? Vice Chair Powers?
Thank you, Madam Chair. Good morning, Ms. Powers.
Good morning, Vice Chair.
It's good to finally hear some numbers, and it seems there was a conversation between you and Mr. Hall that there was a $9 million difference in some calculations depending on whose you followed. Is that correct?
Yes.
Okay. One thing that was asked for at the start of the hearing was about salaries. I know there are some accounting adjustments being made, but for the ratepayer who may be listening in, what would be the packages for the top 4 executives and numbers?
Vice Chair, I'm sorry, I do not have that information. I can share with you that the amount for any Duke Energy executive, particularly the top executives that support all the operating entities, is a very small portion. I don't have a quantification of that for you in front of me to share. It's certainly in the company's work papers, but I don't have that work paper before me to share with you those details.
Well, I know in the Charlotte Business Journal said in 2014 that the one salary was $4.3 million. I have to assume they haven't gone down in any way.
I don't know.
Okay. Thank you, ma'am.
You're welcome. Thank you.
Commissioners? Ms. Powers, I have a couple of questions, please.
Yes, Chair.
When you say the residential rate of 82 cents per month, approximately increase of 82 cents per month, it's an average residential customer. What constitutes an average residential customer? Is it usage or what?
Yes, I think usage is the best way to conceptualize it. The analysis performed is at weather normalized usage. And so under normal weather conditions, and a residential customer in the state of South Carolina uses approximately 570 therms of natural gas per year. And so that quantification of the 82 cents per month is pricing out the annual increase, the annual amount based on 570 decatherms of usage, and then dividing it by 12. It's levelized. Certainly there can be other ways to look at it since there is seasonality in customer usage, but it's represented in that manner in the calculation you asked about.
Thank you for that. Also included with your testimony and your exhibits are a number of tariff changes, tariff revisions, tariff updates to the tariff sheets. And,
yes.
Has any party disputed or objected to any of those revisions?
They have not.
Okay, I believe I remember ORS witness Mr. Seaman Wynn indicating that ORS did not have any objection, but no other party has objected. Is that correct?
That is correct.
And I particularly looked at the GCRM, and really those were just very minor, almost changing lowercase letters to capital letters. I think there was no substantive change to the GCRM. Is that correct?
I'm going to look right now. I want to make sure That's correct. There were some defined terms in our tariff, and so the GCR version didn't have all of those defined terms with the capitalization. You're correct. No substantive changes were proposed.
Okay. That's all I have. Thank you very much. Let me check with commissioners. Just a moment. Any other commissioners with questions for this witness? Hearing none. Mr. Richardson, any redirect?
Just briefly, Madam Chair. Ms. Powers, you discussed the statutory RSA requirements with Mr. Hall. In practice, each RSA proceeding entails a full RS audit of Piedmont's expenses, which also include adjustments, correct?
Correct.
Can you explain the annual process, the annual RSA process?
Yes. The company files its computation of its cost of service based on a historic test period. The RSA requires that that historic test period be the most recent 12 months ended March 31st. That annual filing, that triggers the rate, that triggers the ORS's audit, and subsequent this proceeding, the RSA proceeding, is filed each June 15th. So the company uses its actual, from its books and records, its actual expenses, revenues, and makes certain pro forma and accounting adjustments for it. And those ultimately are filed by the company under the, based on the return on equity as authorized in the last general rate case. And as Mr. Hall mentioned, it's a 12.6 from a 2002 rate case. The ORS conducts an audit, and for many years, the company has ultimately agreed in a settlement to propose the rate adjustment be made on a different ROE. The most recent occurrence was based on a 9.8 ROE, and rates associated with that are presented to this commission along with the settlement agreement and the results of the ORS's audit for approval.
Thank you, Ms. Powers. Madam Chair, that's all I had.
Thank you. Anything further for this witness? Ms. Powers, thank you for your testimony today. You may step down.
Thank you, Madam Chair, members of the commission.
Madam Chair, I ask that Ms. Powers please be excused, subject to your warning.
Thank you. That subject to just at your peril.
Thank you.
Anything else from Piedmont?
No, ma'am. At this time, Piedmont does not have any other additional witnesses.
Okay. Do we need to, let's go ahead and do some housekeeping and get in the stipulated testimony of your witnesses, please. Who's going to handle that?
I will handle Ms. Cousins, and I believe Mr. Jeffries will handle Ms. Bowman. That's all right with the parties.
Well, we've got a lot of other witness. We got the stipulated testimony and exhibits that need to be entered as well.
I'll do it, Madam Chair.
Okay. Thank you.
Yes, Piedmont would move consistent with the stipulation of the parties in the settlement in this case to have the various direct rebuttal and settlement testimonies of the following witnesses.
Mr. Jeffries, let me interrupt. I would like to do them individually so that we can have hearing exhibits or any exhibits marked appropriately as hearing exhibits.
I'm happy to do that, Madam Chair. I don't have the exhibit numbers at my fingertips at this second. If we could maybe take a 10-minute break and let me get
Mr. Jeffries, if we can just go witness by witness, I think I may have the numbers.
Okay, excellent. Thank you. And I apologize for not having that in front of me. I think we'll start with Ms. Bowman. Ms. Bowman filed direct rebuttal and settlement testimony. And I believe with respect to Ms. Bowman, she had exhibits in each one of those testimonies. So we would move that Ms. Bowman's direct, rebuttal, and settlement testimonies be entered into the record as if given orally from the stand.
Just a second, please. Okay. Let's do this. Ms. Bowman's pre-filed direct testimony, her pre-filed rebuttal testimony, and pre-filed settlement testimony, will all be entered into the record as if given orally from the stand. I do want to do separate hearing exhibits for her exhibits.
And I do have her exhibits. Okay. I do have her exhibits.
Ms. Bowman's direct exhibits, I think, are 1 through 8. Is that correct?
That's correct.
That will be marked for identification as hearing exhibit 13 and entered into the record of the case. Her rebuttal exhibits are what, Mr. Jeffries?
They're QPB1 and QPB2.
Those will be marked for identification as hearing exhibit 14 and entered into the record of the case. And then settlement exhibits
are QPB1 through QPB3.
Those will be marked as a composite exhibit for identification number 15 and entered into the record of the case. Okay, next.
Yes, next we've got Ms. Cousins' pre-filed testimony. Ms. Cousins also has direct rebuttal and settlement testimony, and the company would move that those testimonies be entered into the record as if given orally from the stand.
Ms. Cousins' pre-filed direct, pre-filed rebuttal, and pre-filed settlement testimony will be entered into the record as if given orally from the stand.
And Ms. Cousins has exhibits attached to her direct testimony, exhibits 1 through 7, and we would ask that they be entered into the record as a composite hearing exhibit.
Ms. Cousins' direct pre-filed testimonies, exhibits 1 through 7, will be marked for identification as hearing exhibit 16 and entered into the record of the case.
Ms. Cousins also had exhibits attached to her settlement testimony, exhibits 1 through 5, and we would move that they be admitted into evidence as a composite hearing exhibit.
Ms. Cousins' settlement or exhibits attached to her settlement testimony will be a composite exhibit marked for identification as hearing exhibit 17 and entered into the evidence of this case.
I believe that completes Ms. Cousins. Piedmont would request next that Mr. Weintraub's direct testimony be entered into the record as if given orally from the stand.
Mr. Weintraub's, is that just direct?
Just direct.
Just direct testimony will be entered into the record as if given orally from the stand. Here's my list.
And I don't believe Mr. Weintraub had any exhibits attached to his direct testimony.
I don't show they do, that he does.
The next witness is Mr. Weisker, who filed direct testimony, and the company would move that his direct testimony be entered into the record as if given orally from the stand.
Mr. Weisker's direct testimony will be admitted into the record as if given orally.
And Mr. Weisker did have exhibits attached to his direct testimony, exhibits 1 and 2, and Piedmont would 18. Ask that they be admitted into evidence as a composite hearing exhibit.
Mr. Weisker's exhibits 1 and 2 will be admitted as a composite exhibit marked for identification as hearing exhibit 18 and entered into the record of the case.
Thank you, Madam Chair. Next would be Mr. Watson's testimony, our outside depreciation expert. He filed only rebuttal testimony in this proceeding, and we would ask that his rebuttal testimony be entered into the record as if given orally from the stand.
Mr. Watson's rebuttal testimony will be entered into the record as if given orally from the stand. Now, have we received verifications or affidavits on these testimonies, Mr. Jeffries?
I have been in contact with my assistant, who I believe has and is in the process of filing those. As far as I understand it, we have verifications from all of the non-live testifying witnesses, and they should be filed momentarily.
Thank you. Okay, so Mr. Watson's testimony is now in, and I believe he had some exhibits as well.
He did. He had 13 exhibits attached to his rebuttal testimony, numbered 1 through 13. We would move that they be admitted into evidence as a composite hearing exhibit.
Mr. Watson's rebuttal exhibits DAW 1 through 13 will be marked for identification as hearing exhibit 19 and received into the evidence of this case.
And then I believe finally we have Mr. Stewart, who filed rebuttal testimony. And we would ask that Mr. Stewart's rebuttal testimony be entered into the record as if given orally from the stand.
Mr. Stewart's rebuttal testimony will be placed into the record as if given orally from the stand.
And it does not appear to me that Mr. Stewart had any exhibits with his testimony.
Has that got everybody, Mr. Jeffries?
I believe so. Let me check one more time real quickly. Everyone else will testify live, so I believe we have covered Piedmont's witnesses.
Okay. Thank you, Mr. Jeffries. Anything else from Piedmont?
No, Madam Chair.
Okay. Energy Users Committee, we have your witness and exhibits. Is there anything else from the Energy Users Committee?
No, ma'am, nothing further from the energy users. Thank you so much.
Department of Consumer Affairs, is there anything else that needs?
No, ma'am, nothing else from the department.
Okay. Now to ORS. Mr. Huber.
Thank you, Madam Chair. Michael Seaman Wynn will be testifying. I would ask if the commission would mind taking maybe a 10-minute break to allow us to finish getting set up.
That'll be fine. We will recess. It is, what time is it? It is about 10:40. How about if we break until 10:55? About 15 minutes?
Thank you, Madam Chair.
Thank you. We're in recess until 10:55. Thank you. Good morning and welcome back to the Public Service Commission of South Carolina. We are continuing with the hearing in docket number 2022-89G. It's the rate case application of Piedmont Natural Gas Company Incorporated. Let's take a roll call of commissioners. Appearing virtually, we have Commissioner Carolee Williams and Commissioner Irvin. Here in the hearing room, we have Commissioner Justin Williams, Vice Chair Powers, Commissioner Thomas, Commissioner Caston, and Chair Belser. I've been told we have all the attorneys or the parties represented, so at this point, we will recognize the Office of Regulatory Staff.
Thank you, Madam Chair. This is Chris Huber with ORS. ORS calls Michael L. Seaman Wynn.
Mr. Seaman Wynn, there you are. Please wait for the court reporter to swear you in, please.
Thank you. Will you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Huber, please go ahead.
Thank you, Madam Chair. Mr. Seaman Wynn, can you please state your name, by whom you are employed, and in what capacity?
My name is Michael Seaman Wynn. I am the Deputy Director of Energy Operations at the South Carolina Office of Regulatory Staff.
Are you the same Michael Seaman Wynn who pre-filed 12 pages of direct testimony in this case on July 12th, 2022?
Yes, I am.
Do you have any changes or corrections to your pre-filed testimony?
No, I do not.
And if I asked you the same questions today, would your answers be the same?
Yes, they would.
Madam Chair, I move that the pre-filed direct testimony of Michael Seaman Wynn be entered into the record of the case as if given orally from the stand.
Mr. Huber, is this both direct and rebuttal? I'm sorry, I was trying to follow on my sheet and got lost.
I'm just on direct right now.
Thank you.
Both. Okay.
Thank you, sir. Mr. Seaman Wynn's direct pre-file testimony will be entered into the record as if given orally from the stand.
Thank you. Mr. Seaman Wynn, are you also the same Michael Seaman Wynn who pre-filed 3 pages of cerebral testimony in this case on August 5th, 2022?
Yes, I am.
Do you have any changes or corrections to your pre-filed cerebral testimony?
No, I do not.
And if I ask you the same questions today, would your answers be the same?
Yes, they would.
Madam Chair, I move that the pre-filed cerebral testimony of Michael Seaman Wynn be entered into the record of the case as if given orally from the stand.
Mr. Seaman Wynn's rebuttal testimony will be entered into the record as if given orally from the stand.
Thank you, Madam Chair. Mr. Seaman Wynn, have you reviewed the stipulation that was filed in this case into which all the parties entered?
Yes, I have.
As a representative of ORS, do you submit the stipulation is in the public interest?
Yes.
Thank you, Mr. Seaman Wynn. Madam Chair, Mr. Seaman Wynn is now available for questions.
Thank you, Mr. Huber. Questions from the parties, and I will look to Mr. Elliott first.
No questions. Thank you, Madam Chair.
Mr. Hall for Department of Consumer Affairs.
No questions, thank you.
Mr. Jeffries or Mr. Richardson for Piedmont.
No questions, Madam Chair.
Thank you. Commissioners, questions for Mr. Seaman Wynn?
Madam Chair.
Commissioner Jay Williams.
Thank you, Madam Chair. Good morning, Mr. Seaman Wynn.
Good morning, Commissioner Williams.
Good to see you again. Hate you couldn't be here in person, but these are the days and times we live in.
We're fully prepared to be there, sir, but we're happy with this option as well.
Understood. Thank you for working with us. So if you would indulge me a little bit, I want to talk to you a little bit about ORS, its role generally, and its role in this case, and about the stipulation. We spent about 2 full days hearing testimony about ROE, capital structure, and other items, but we really haven't talked much about the stipulation. So I want to talk with you about that today. Could you please explain to us the role of the Office of Regulatory Staff?
Yes, sir. The Office of Regulatory Staff represents pardon me for not getting the language correct right away, the public interest as defined in 58.410.
Okay. And what did the Office of Regulatory Staff do in this case as it pertains to settlement until this stipulation, to ensure that the public interest was represented and all classes of customers were considered when stipulating to the agreement?
Well, Commissioner, I was not at the negotiation table while the parties were discussing and negotiating the stipulation. But what I can say is that the stipulation is a result of earnest good faith and complex negotiations between all the parties with numerous diverse interests. And in the spirit of collaboration, each of the parties did make compromises from their original positions to achieve a balanced resolution.
Okay, understood. Is it fair to say that whoever was at the negotiation table and whoever worked on the settlement, they looked at each, and I keep saying settlement, I'm sorry, the stipulation, that they looked at each of the terms agreed to and considered the impact that it would have on each customer class and the public interest as a whole?
Yes, sir.
Okay. And in doing so, the Office of Regulatory Staff does not feel that no customer class will be harmed in any way, and that the public interest will be well served by accepting the terms of the settlement?
Yes, sir.
Okay. Did you have opportunity to listen to all the testimony?
Except for this morning, yes, sir.
Okay. I want to take you to witness Rothschild's testimony. He testified for a significant period of time, but one of the things he testified to was a concern about overpayment. He believed that the ROI and capital structure stipulated to lead to overpayment. Is there any concern, overpayment by, let me be more specific, a overpayment by ratepayers leading to over-earning by the utility, in this case Piedmont? Is there any concern by the Office of Regulatory Staff that if this commission were to accept the stipulation, that it would lead to overpayment by ratepayers, any class of ratepayer, and potentially over-earning by Piedmont?
Commissioner, I am not an ROE witness in this case. I'm not an ROE expert. I believe that those questions would be better addressed by one of the numerous witnesses that you heard from yesterday, sir.
Well, I'm not asking you specifically about what ROE we should select. I just want to know whether or not there's any concern about an overpayment based on the stipulation.
Given the stipulation terms as agreed to by all of the parties, I don't believe so. No, sir.
Okay. Indulge me one minute here. Let me check my list. All right, I want to turn your attention now to risk. There was a lot of testimony regarding the risk of accepting the stipulation and the risk of rejecting the stipulation. I asked you about the risk of overpayment, and my understanding is based on the terms of the stipulation, if the commission were to accept it, that the Office of Regulatory Staff does not believe there's a risk to ratepayers for overpayment. So we established that, right?
Okay.
Okay. can you testify to any potential risk of rejecting the settlement? Risk to ratepayers, risk to the public interest, other risks that maybe the commission is not aware of if we were to reject the settlement? The
No,
stipulation,
sir, I'm not in a
excuse me.
position to testify to that.
Oh, okay. Is there anyone at the Office of Regulatory Staff that's in the position to testify to that?
I don't believe so, no, sir.
Okay. But was there not any level of risk analysis performed regarding the terms of the stipulation?
Not to my knowledge, no, sir.
Okay. Well, how did you determine that it was in the settlement is in the public, the stipulation is in the public interest?
The Commissioner, as I stated before, it is an agreement that, save for two issues, have been agreed upon by all of the parties in the case. It is the result of good faith, earnest, and complex negotiations, and all of the parties made compromises in their initial positions to result in a stipulation that was brought forward to this commission. The result of the stipulation results in only a 1.3% increase to residential customers and small increases for other small changes to other customer classes as well.
I'm sorry, I had my microphone off. Okay, understood. So I just want to make sure that I thoroughly unpack this, so when whatever decision the commission makes, we can clearly articulate it in our order. So if we were to find that the settlement is in the public interest, the ORS position is that the settlement is in the public interest because of the 1.3% increase and what else?
That is a resolution to the majority of the issues in this case. It's agreed upon by all of the parties in the case, save for the two subjects that you brought up before and heard from witnesses from yesterday, that it will allow the company to continue to provide safe and reliable natural gas service to its customers.
All right, thank you very much, sir.
Yes, sir.
Thank you, Commissioner Williams. Commissioners, any other questions for this witness?
Madam Chair.
Commissioner Irvin?
Madam Chair. Stephen Wynn, how are you, sir?
Well, sir, thank you.
Wouldn't it be appropriate for the attorneys who represented the Office of Regulatory Staff in this proceeding to talk about the reasonableness of the settlement agreement, since they were the signatories to the agreement?
Yes, Commissioner, it would.
They're the ones that negotiated the terms of the settlement agreement, correct?
Again, I was not at the settlement table. However, ORS has a team of both attorneys and non-attorneys who are typically at the negotiation table. ORS senior management, as well as legal representation, I'm sure were both heavily involved in the negotiations with all of the parties.
All right. And so just because you don't know about a review of certain matters doesn't mean that somebody else on your team didn't look at it. Is that correct? You're confident that it was properly reviewed by the ORS staff and their attorneys, correct?
Commissioner, ORS would not have signed a stipulation if it had not been thoroughly reviewed, if not all factors were analyzed, and that if it was not in the public interest of South Carolina, we would not have signed it.
Thank you, sir. No further questions.
Thank you, Commissioner. Commissioners, any further questions for this witness? Any redirect, Mr. Huber?
No redirect, Madam Chair. Thank you.
Thank you, Mr. Huber. Thank you, Mr. Seaman Wynn. You may stand down.
Thank you, Madam Chair.
Mr. Huber, anything else from ORS?
ORS would now move to put the rest of his testimony into the record if this is the appropriate time. Ms. Given is prepared to go through the remaining testimony and exhibits.
Thank you. Ms. Given, you're recognized.
Good morning, Madam Chair. If it's permissible with you, I'd like to start with Anthony Brazino's testimony.
Thank you.
Mr. Brazino filed corrected direct testimony with the commission yesterday consisting of 64 pages. I would move that his corrected direct testimony be entered into the record of this case as if given orally from the stand.
And I believe there was just one minor correction to that testimony that was in a footnote. Is that correct?
That is correct. It was a ministerial change to a footnote.
Okay. Mr. Brazino's corrected direct exhibit will be entered into the record as if given orally from the stand. And I believe we have received affidavits or verifications from ORS regarding these witnesses.
That is correct for all stipulating witnesses, Madam Chair.
Okay.
With Mr. Brazino's corrected direct testimony, there are 6 exhibits labeled ADB 1 through ADB 6. And I would move those into the record as well.
And there were no changes to the exhibits, correct?
That is correct, Madam Chair. There were no changes to the exhibits.
Mr. Brazino's pre-filed direct exhibits ADB 1 through 6 will be a composite exhibit marked as marked for identification as hearing exhibit number 20 and entered into the record of this case.
Thank you, Madam Chair. Mr. Brazino also filed surrebuttal testimony in this case consisting of 13 pages. I would move that his surrebuttal testimony be entered into the record of this case as if given orally from the stand.
Mr. Brazino's surrebuttal testimony will be entered into the record as if given orally from the stand.
Thank you, Madam Chair. I will move next to witness Daniel J. Rowland IV. Mr. Rowland filed direct testimony with the commission consisting of 8 pages. I would move that his direct testimony be entered into the record of this case as if given orally from the stand.
Mr. Rowland's direct pre-filed testimony will be entered into the record as if given orally.
Thank you, Madam Chair. Mr. Rowland also filed 2 pages of surrebuttal testimony in this proceeding. I would move that his surrebuttal testimony be entered into the record of this case as if given orally from the stand.
Mr. Rowland's surrebuttal testimony will be entered into the record as if given orally.
Thank you, Madam Chair. I will move next to David J. Garrett. Mr. Garrett filed 29 pages of direct testimony in this proceeding. I would move that his direct testimony be entered into the record of this case as if given orally from the stand.
I'm sorry. Tell me again, the witness.
Of course, David J. Garrett.
Mr. Garrett's direct pre-filed testimony will be entered into the record as if given orally from the stand.
Thank you, Madam Chair. And with Mr. Garrett's pre-filed direct testimony, there were 11 exhibits marked as DJG1 through DJG11.
And weren't there also appendices?
That is correct, Madam Chair. There were 3 appendices, appendices A through C.
Mr. Garrett's pre-filed appendices A through C and exhibits DJG 1 through 11 will be a composite exhibit marked for identification as hearing exhibit 21 and received into the evidence of this case.
Thank you, Madam Chair. Witness Garrett also filed 4 pages of surrebuttal testimony, and I would ask that his 4 pages of pre-filed surrebuttal testimony be entered into the record of this case as if given orally from the stand.
Mr. Garrett's surrebuttal testimony will be entered into the record as if given from the stand.
Thank you, Madam Chair. And lastly, the final ORS stipulating witness is Glenn A. Watkins. Mr. Watkins pre-filed 29 pages of direct testimony in this case. I would ask that his pre-filed direct testimony be entered into the record of this case as if given orally from the stand.
Mr. Watkins' direct pre-filed testimony will be entered into the record as if given orally.
Thank you, Madam Chair. Mr. Watkins also filed 6 exhibits with his direct testimony. They are marked as GAW1 through GAW6. I would ask that they be marked as a composite hearing exhibit.
Mr. Watkins, direct exhibits GAW 1 through 6 will be a composite hearing exhibit marked for identification as hearing exhibit 22 and entered into the record of this case.
Thank you, Madam Chair. I would next move to Mr. Watkins' pre-filed surrebuttal testimony, which consisted of 11 pages. I would ask that his surrebuttal testimony be entered into the record of this case as if given orally from the stand.
Mr. Watkins' surrebuttal testimony will be entered into the record as if given from the stand.
Thank you, Madam Chair. Finally, Mr. Watkins filed 2 exhibits with his surrebuttal testimony. They are marked as GAW1 and GAW2. I would ask that those be marked as a composite hearing exhibit.
Mr. Watkins' surrebuttal exhibits GAW1 and 2 will be marked as a composite exhibit, will be a composite exhibit marked for identification as hearing exhibit 23 and received into the evidence of this case.
Thank you, Madam Chair, and that concludes the stipulated witnesses from the Office of Regulatory Staff.
Thank you, Ms. Given. Anything else? Parties, have I missed anybody's testimony? Anybody have anything that we've overlooked? Hearing nothing. Commissioners, anything further from the commissioners? And I believe yesterday the parties indicated there were no closing arguments. Is that correct?
Madam Chair, this is Mr. Jeffries for Piedmont. I'd like to make a very short statement. It's 3 points at less than 5 minutes if the commission is comfortable with that.
Mr. Jeffries, please proceed, and any other parties that wish to have a short closing, you will be afforded the same accommodation.
Thank you, Madam Chair. I appreciate the opportunity to sum up the case. I'd like to talk very quickly about 3 relevant points in this case that I think are noteworthy for the Commission's consideration. The first is context. Piedmont has $500 million of rate base underlying its case in this proceeding, and $160 million in operating expenses. And the result of the stipulation, if it were accepted in whole, would be a $20,000 decrease in rates overall, and a very small increase to residential customers of 82 cents per month. And I just wanted to point that out because that's the context in which the commission is undergoing its deliberations in this case. The second point is that there is a settlement in this docket, and it's a settlement as to all issues as between the company, the Office of Regulatory Staff, who, as was pointed out earlier, is responsible for monitoring the public interest in South Carolina. And that settlement results in a meaningful ROE reduction, among other reductions in accounting adjustments that were agreed to by the company. And it would make Piedmont, among gas and electric utilities in South Carolina, the company with the lowest approved ROE among all those companies. The third point I would make is that the proposals of DCA witness Rothschild in this case as to ROE and the capital structure that he would urge upon the commission would be a significant, and I don't think it's an overstatement to say a radical departure from this commission's historical practice, from the way in which natural gas distribution utilities are treated nationally, and also as compared to the way the comparable companies, which all 3 ROE witnesses relied on, are treated by their commissions. And that would have a significant impact on not only Piedmont, but potentially other South Carolina utilities because of the possible reactions of the market to that sort of reduction in ROE and equity structure from that, which is typically been granted by this commission. And those are the only 3 points I wanted to raise. And I, again, thank you for the time to make those. Thank you.
Thank you, Mr. Jeffries. Mr. Elliott, anything on behalf of energy users?
Madam Chair, nothing other than to say that we support the stipulation in its entirety and would defer to Mr. Jeffries and Mr. Huber for any further explanation. Appreciate the opportunity to be heard this week. Thank you so much.
Thank you, Mr. Elliott. Mr. Hall, anything on behalf of DCA?
Yes, I suppose I'll take the time to have a brief closing as well. Thank you. I guess I'll start, just to reiterate, the department did enter certain components of the stipulation agreement, as y'all are well aware of by now. The two we did not enter are the ROE and the capital structure. We just heard from ORS witness Michael Stephen Wynn that he believes the stipulation is in the public interest. I would point out that it's probably safe to assume that ORS also thought its previous ROE recommendations and cap structure recommendations were also in the public interest and are slightly lower than, of course, what's in the settlement agreement. We heard from Mr. Jeffries that the settlement will result in a $20,000 decrease to revenues, but a small increase to residential customers. I think it's also safe to assume that if the ROE issued by the commission is lower than the settlement and the cap structure is lower, that decrease to revenues would be greater, and perhaps there would be no increase to residential customers. We believe and firmly stand by our expert's judgment as applied through the financial models that he used. We've expressed some concerns that we have with the other ROE witnesses. We understand this is a highly technical issue. We do appreciate the commission's time and attention to this as always. I would just say, I guess, the balancing of investor and consumer interest doesn't require that there be a winner one way or another, but requires that the results to be fair. And fairness makes all the parties winners here. The questions we have posed to the commission are essentially this: is it fair to consumers to pay for an investor's return on equity that is based on forecasts, when the cost of equity, in other words, investor expectations, can be determined using current market data instead of using analyst projections that have been shown to be inconsistent or exaggerated? The department's witness, Mr. Rothschild, as he explained to you all, he uses market data whenever possible. The other two witnesses, on the other hand, more often use non-market data like these forecasts we've mentioned. I think when looking at the other components of the two experts' models, you see that without this use of forecast, as Mr. Rothschild testified, they're often much lower, in some cases very much in line with the recommendations of Mr. Rothschild. We once again appreciate the commission's attention, but we chose to pick this ROE and cap structure battle because it was an almost $9 million difference, but also because we believe in the long run that it will be better for all classes of customers for the PSC to realize a utility's true cost of equity is well below those presented by the other witnesses and the stipulation. So once again, we thank you for your time and consideration in these matters. Thank you.
Thank you, Mr. Hall. Mr. Huber, anything from ORS?
Thank you, Madam Chair. I'll be very brief. I would just like to thank the commissioners for their time this week during the hearing. And I would just simply state ORS supports approval of the stipulation as written. Thank you, Madam Chair.
Thank you, Mr. Huber. I think I've hit all the parties here. Before we close, I would like to thank the parties, their representatives, both witnesses and attorneys, for the excellent job that y'all have put forth today or this week. And as always, I appreciate y'all's professionalism and the way that you conduct yourselves in the hearings. It certainly makes things easier. And with that, I will ask counsel, either Ms. Moser or Mr. Stark will get with y'all on dates for proposed orders. The sooner we can get them in, the better. It gives us more time to review them. So just keep that in mind. I know we'll be awaiting a transcript of the hearing, but we do have a statutory deadline on this case to get an order out. So the sooner we can get those, the better. I would encourage you with that. And if there's nothing further to come before the commission, Commissioner
Madam Chair.
Thomas?
Thank you. Just one short, brief comment. I would just like to say thank you to all of the parties for all of the hard work that you put into this from start to finish. Anything from the negotiations that you all worked very hard on, and the effort that you put into your testimony, both pre-filed and throughout this proceeding. It's very obvious that a lot of work went into this by all the parties, and I appreciate it. Thank you.
Thank you, Commissioner. If there's nothing further, we will adjourn this proceeding and await the proposed orders, and then y'all will await our decision. Thank you.